Welcome to this online course in Constitutional Law. For our case, this is Constitutions and Legal System of East Africa. My name is Vicky Msugi. I'll be the instructor for this course. To begin with, I would like to outline for you what this course is all about. This course is divided into 6 modules. For our case, we have divided it into 2 parts. We have part 1, which comprises of 3 modules, and we have lectures in every modules. For instance, part 1, module 1 is all about the historical development of the constitutional and legal system of East Africa. We have module 2, which will comprise of historical development of some constitutions doctrines, and we have module 3, which is development of the United Republic of Tanzania Constitution of 1977 as amended from time to time. We'll also have part 2, which will comprise of module 4, 5, and 6, whereby for module 4, we'll have the development of the Zanzibar Constitution of 1984. Module 5 will have the court system during the British rule, and we'll have module 6, which will comprise of the present court system in Tanzania. So that is all about the constitution and legal system of East Africa. So as I've said, part 1 constitutes of the following modules, and I'll go direct to module 1, which is historical development of constitution and legal system of East Africa. In this module, we'll trace the development and the origin of different societies, early societies' constitutions, as well as the emergence of state and law. So what modules? We have the introduction to legal system of East Africa, whereby we'll know what is the legal system and what is the legal system of each country in East Africa, where we will see the legal system of Uganda, the legal system of Kenya, the legal system of Tanzania. We'll have the state and law. We'll see how did state and law emerge. We'll have the constitutions. We'll see different things like what is constitution, sources of constitutions, and things of that nature. We'll have the Gentile constitution, Greece, ancients, and Rome societies. We'll have the tribal constitution in Germanic societies. We'll see slave state legal system, and last, we'll see the feudal state legal system. So this is all about the historical development of constitutions in, as I've said earlier, in early societies.
Madam, sogea kwa mbele kidogo.
Haya mambo haya. Hata njaa imekata.
Tunakwenda vizuri.
Tunakwenda? What do we expect for the student to achieve at the end of this lecture? I will expect my students to know what is the legal system of a particular country. For our case, I've said earlier, we are going to trace the legal systems of East African countries, that is Uganda, Kenya, and Tanzania. I will expect the student or students to identify the different global legal system. So we'll not only base on East Africa countries' legal system, we'll also see the historical background of the different global legal systems. At the end, I will expect the student to be able to identify the features or characteristics of each legal system. So this is the objectives of this course. What is legal system? I will say it very briefly. Legal system, when we talk of a legal system of any country, this presupposes existence of law, constitution, regulations, instrument of their enforcement, and last but not least, we expect the instrument of decision making. So when we have these things at one, we say that that particular country is having a certain legal system. What is legal system? As I've said earlier, that part of this lecture we are going to see the legal systems of the East African countries. When you talk of the legal system, you mean this presupposes existence of law, constitutions, regulations, the instrument for the enforcement of those regulations, as well as the instruments for decision making. So if I put them in one bucket, I would say the legal system of any country comprises of legislature, executive, and judicial organs. So that is the legal system when you talk of legal system of any country. When you talk of the types of legal system, it means we have the civil law system, we have the common law system, and the socialist legal system. Other legal systems may include Islamic law, Hindu law, customary law, and canon law. These are situated outside these three categories of legal system. Civil law system, or civil law legal system. This originated in continental Europe, developed on the basis of Roman civil law. The system was dominated by writings of jurists, which later it was dominated by legislation and written law. So this is the civil law system. This kind of system is applicable in countries like France, Italy, Germany, Spain, and Portugal. So in Tanzania, we don't apply civil legal system. When you talk of the features of civil law system or civil legal system, you talk of things like the task to determine and formulate the law. It falls principally on the legal scholars. This system has evolved as an essential private law, that is, a law tailored to regulate the private relationship between individual citizens. So this is basically meant to regulate the relationship among individuals. The third feature of the civil law system is that court proceedings in a civil law system are based on the inquisitorial procedures. In this case, the judge assumes a more dominant role in questioning or eliciting information from the parties. So this is of more, as I've said, judge assume more dominant role. It is not a kind of a participatory kind of relationship between the judge and the parties to the case. Let's go to another type of the legal system, which is the common law system. This is based on the English legal system, of which it is the type of legal system that is applicable in Tanzania. The English legal system operates only within England and Wales. like Northern Ireland, Scotland. The common law has its origin in Anglo-Saxon customary rules by judges after the Norman Conquest in 1066. Before the coming of William the Conqueror in 1066, there already existed a primitive legal system, which was consisted mainly of customary rules and written laws, which were codes of law compiled by Anglo-Saxon kings. Before the existence of common law legal system or common law system, we had the primitive legal system of England, of which this was consisted of customary rules and written laws. So this was also applicable in our country. So geographically, we had the communal courts, which were the courts which were used to decide different cases in those areas. The courts, these communal courts, used to administer the customary rules. As I've said earlier, we had the communal courts, whereby these communal courts applied customary rules and written laws, which were compiled by the Anglo-Saxon kings. In these communal courts, these courts were presided over by an official known as the sheriff. This sheriff was known as the representative of the king. So, common law was formulated in 1215. That is the year where the common law was formulated from the indigenous customs by royal judges, who were sent out as representatives of the king to administer justice throughout the country. In this case, coming before the royal judges would apply these principles of laws, announce their decision, and give the reasons for their decisions. As I've said earlier, that the king had his own representatives, so they were performing different duties, including solving different disputes in the societies, whereby before the emergence of the common law system, these representatives of the kings would use customary rules and written laws. So here we see how common law system was formulated by these representatives of the king. The doctrine of binding precedent decided was also established in the 19th century to ensure consistency and predictability in the common law system. What are the characteristics of the common law system? Lack of influence of Roman law. This is the first characteristics. We have the importance of case law. As I've said earlier, you see where the representatives of the kings were out there to solve different disputes, and at the end of the day, they would give out the reasons for their decisions. So from there, we can see the importance of case laws, the binding doctrines of precedent, and the adversarial court procedure, that whatever decision that was made by that particular court, or as we have seen earlier, we had the communal courts where they were presided by the representative of the king. some called sheriffs. The decision made there was a binding decision. We also have the term common law refers to law which is not contained in statute but is the product of case law. As I've said earlier, how common law was formulated. This was formulated by a situation where the representatives of the king would go out, solve different disputes, make decisions, tell reasons of their decisions, and at the end of the day, that particular decision would become a binding decision. We also have the doctrine of equity. The doctrine of equity imprises for natural justice or fairness. In the English legal system, equity refers to a specific body of law which is different to the common law. So we have the common law system and we have the doctrine of equity. The doctrine of equity, simply justice or fairness. In this sense, equity consists of principles of law which were developed in the 15th century by the Court of Chancery to remedy the inadequacies of the common law. So from this perspective, we can see that the common law system had some gaps. So as a result, they looked upon on how do we cure these gaps. There emerged the doctrine of equity, which said more on natural justice and fairness. In that case, we cannot per se say that the common law system had it was not fair, or a lot of decisions made were not fair, but we said there are some gaps here and there which required more focus on justice and fairness. What factors gave rise to growth of doctrine of equity? As I've said earlier, that the common law system had some gaps. There emerged the doctrine of equity to cure those gaps which would be seen in the common law system. Firstly, common law system was formed primarily by roaming judges who traveled in circuits to resolve individual disputes. I talked about this, that judges will go out, solve disputes, make decisions, give out reasons for their decisions. There comes common law system. Secondly, the reasons for growth of doctrine of equity. Judgments given by the roaming judges subsequently formed sources of law through the introduction of the doctrine of judicial precedent. And thirdly, the origin of common law is linked to royal power. So this could be the reasons, these are the reasons for the growth of the doctrine of equity. So we have seen the common law system. Now let's see another type of legal system. We have socialist legal system. What is socialist legal system? This constitutes the third category of world legal regimes. The system originated in the Union of Soviet Socialist republics since 1917, Socialist Revolution. The society under this socialist legal system is to be created in Communist one under the aegis of fraternity, where there will be no more state and no more law. So that is the socialist legal system. In this socialist legal system, state and law will be made unnecessary by a new feeling of social solidarity. It is contended further that in a communist society, the instrument of coercion will disappear and the social relations will be ruled primarily by communist morality. So we find most of the time we find this kind of socialist legal system with the communist societies. Prior to 1917, the legal system applicable in countries which later constituted the now de facto USSR, as we all aware of, was the civil law system. I'll give a few examples of the countries. I'll give a few examples of the country that followed this socialist legal system. Example is Yugoslavia, Democratic Republic of Germany, whereby they started disintegrating in 1990. For this reason, the law applicable during the transition period to communism has basically remained that tailored on the civil legal system. What are the basic features of a socialist legal system, or the characteristics of a socialist legal system? It is revolutionary in nature, as opposed to the civil legal system. The primary objective of the socialist legal system or socialist jurist is to overturn society and create the condition of a new social order in which the very concept of state and law will be disappeared. Another feature or characteristic of the socialist legal system is that the only source of socialist rules of law lies within the legislature, who express popular will, narrow guided by the ruling political parties. I've said earlier, this socialist kind of legal system is mostly seen in communist parties or communist societies. Another feature of the socialist legal system is that the scope of private law is narrowed at the expense of public law. Also, in as far as philosophy of communist parties is concerned, it is collectivization and public ownership of the means of production. So this is all about the socialist legal system. Before going to see state and law, let me tell you briefly on what we have discussed in the first lecture, where we have seen the dimensions of the constitution of the different societies' constitutions. We have seen the meaning of legal system. We have seen the types of legal system, where we saw the civil law system, the common law system, and the socialist system, plus their basic features or characteristics. Now let's see the emergence of state and law. What do I expect you as a student to know after this lecture? I expect you to identify the broad theories of state and law, to define law, differentiate law from other social rules. I expect you as a student to explain in details the nature of law. I expect you to explain how law was or is created. And last but not least, I would expect you as a student to analyze the relationship between the state and define and explain the origin of the state. The basic question to ask ourselves is, have laws always existed? So, knowing these questions, how do we get proper answers for our questions? This is through going different theories of the emergence of state and law. One would ask himself, have law always existed? Same as, have man always existed? We have several theories on the emergence of state and law. The first theory, which we are going to see, is the idealist world outlook. Thus, according to this theory, state and law are God-given, and for that case, they are eternal categories which over and above man and society general. So this is according to this theory, which is called idealist world outlook. The second theory is materialist world outlook. In order to study and comprehend the origin and nature of state and law as a social institution, it is important to consider more of production at each particular stage of human development. So this is according to the second theory. This is more reflected on the mode of production, which presupposes the investigation of productive forces, the production relations, and the social relationship. That is why this is called materialistic world outlook theory. This theory was proposed by the theorist scholar Marxist. This is one of the famous scholars in the history of state and law. They relocate the origin of state and law at a particular stage of human development. According to Marx and Engels, these were the very first scholars as far as the emergence of state and law is concerned. They were of the following view: that state and law did not exist because of the low levels of development of productive forces, production, relation, and social relation, or simply because of the low level of production or the mode of production. as I've said earlier, their theory was called materialistic world outlook. So they basically looked on the productive forces, production relation, and social relation. According to these two scholars, state and law emerged when there was tremendous improvement in the productive forces. So this was their views in as far as the emergence of state and law is concerned. What is law? Law, as the terminology itself presupposes, it has been defined by different scholars. For this case, I will mention few famous scholars in the definition of law itself. We have John Austin, who is very famous and one of the very early scholars, who defined law as a system of rules of social behavior. The rules are generally because they do not deal expressly with a single person, but with a group of human beings. So this is according to John Austin. As you can see, the title of his book, I've shown it there. But again, it is furthermore said that the rules are generally because they describe a possible human behavior in a general, abstract way. However, it should be emphasized here that law is not concerned with every human kind or every human behavior, but with social behavior of a man. His behavior within a given society, his behavior as far as he materializes certain social relation, law addresses itself to man as a social being. So we have also another definition of law as a set of general rules that defines some general characteristics by which a certain group of people may be distinguished from other groups. So law defines some general characteristics of this particular group of people differ from another particular group of people. And it presupposes the possible ways of human behavior from other possible ways. We have another scholar who also discussed on the emergence of state and law, which is called Friedrich Engels. According to this scholar, law and its development are closely connected. Law plus development, connection. With the division of society into classes in the course of long historical period. He said, since society split up into classes, economically dominant classes guaranteed its role by using the state to create and to enforce a legal system. Law, therefore, expressed the will of the economically and political dominant classes. Unlike other social rules, law is a system of rules of a special kind. One of the basic characteristics that distinguish law from other social rules is its normativity. What do I mean when I say normativity? Normativity means members of a particular society are bound to behave in accordance with the law. law is binding. It is not mere advisory. So you are supposed to act in accordance with the law. Accordingly, the statement of the law saying what a person is allowed, obliged to do, or not allowed to do are usually followed by a statement describing the sanctions or punishment. So that is the point where I say law is of its special nature or of a different kind to other social rules. Let's see the function of law in states. As I've said earlier, law is a system of social rules that regulates in a general and binding manners the behavior of a man as a social being in a given society. So, law regulates behaviors of man in a society. Without social rules, there can be no orderly society interaction, no permanent reproduction of socio-economic relationship, no social order or whatever kind. So, law regulates society. Law regulates behaviors of members of that particular society. As I've said, without social rules, without law, there can be no permanent production, no socio-economic relation, no social order. Then the state cannot be in a settled mood. The state organizes and protects the socio-economic and the socio-economic fundamentals and the political institutions of a given society by providing legal rules. When you say legal rules, we mean laws necessary to sustain the following issues. One of the necessary issues is to subsume the various interests within the society. Another issue is for the reproduction of socio-economic and political conditions in the interests of the ruling class as a whole. For the solving of conflict in a peaceful way, including conflict between members and groups of a ruling class. We have other social norms for regulating social behavior. We have rules of morality, we have customs, we have organizational rules. All of this regulates social behaviors. We have difference between social norms and law. As I've said earlier in different definitions, law first of all, law is created by the state. This means law is either enacted or formulated by the competent state organ, such as the legislature, the courts, and the executive. So law is created by the state. Social norms or customs are attained by force of law only if they are recognized by the state. So social norms, they are attained the force of law only if they are recognized by the state. That means they can be declared to be regarded as law when they are recognized by the state. So that is the difference between social norms and the law. Not all social norms existing in the society are transformed by the state into law. As I've said earlier, only if they are recognized by the state, then the state can push it or can push for them to be enacted or to be assented by the president to become a law of a particular issue. We have seen in lecture 2, where it was all about state and law. We have seen the emergence of state and law. We have seen the different definitions of state as well as law. We have gone through different theories on the emergence of state and law, their characteristics, their different features. We have seen social norms as they differ to social rules and law. Now let's go and see constitution as another topic in this area. It is said that there have never been consensus among scholars on the right definition of a constitution. I would say from a number of scholars where they have tried to define the term constitution, that constitution is the fundamental document of a particular country. It can be a written document or a non-written document. For instance, in Tanzania, we have the Constitution of the United Republic of Tanzania of 1977, as amended from time to time, which is a written and codified document. So, again, we have another issue on the definition of constitution, which is to deny that pre-class or tribal society had a constitution, and to put into doubt that the constitutional character of a state whose constitution are not necessarily enshrined in one legal document. So this is basically the theory of how constitution was defined in a different societies. It is also the continuation whereby, to some extent, the definition of a constitution to a document also underplays the role of a customs. So it is also the continuation on how it brought different views on how constitution can be defined. Ideas about the contemporary constitution began to emerge in 17th century. So this is when the ideas of a constitution began to emerge. Now, I said earlier very briefly on how we can define constitution. It is basically, in a simple definition, we say it's the fundamental document of a particular country. It governs all the other laws. That laws, in order to be enforced, it has to adhere to the constitution of that particular country. Now let's see how different scholars define the term constitution. We have a very famous scholar, Wade and Philip, who tried to define the term constitution as a document having special legal sanctity, which sets out the framework and the principal functions of the organs of government of a state, and declares the principles governing of the operation of those organs. So this is according to Wade and Phillips. We have another definition by Ware. This is a scholar from UK who defined the constitutions, or tried to describe the constitution as a whole system of a government of a country, the collection of rules which establish and regulate or govern the government. These rules, according to Ware, these rules are partly legal in the sense that courts of law will recognize and apply them, and partly non-legal or extralegal taking the form of usage. So it's all about the rules that governing the governments. We have, this is also another definition by the same scholar, who contends that in almost every country in the world, except Britain, the world constitution is used in a narrow sense than in the first definitions. So this is according to this scholar. We have another definition, and take note that we are going through the definitions of the constitutions from different scholars. From the very beginning of my lecture, I've said from the beginning we had not have a consistent definition of a constitution. So every scholar tried to come up with a definition to see which one can fit in the definition of constitution. We have another definition from the Marxists. This is also another famous jurist of those years, who defined a constitution as a fundamental act of legislation which reflects the will of the ruling class. Apart from defining the political and social establishment, the principles of the structure of the government, agency and their activities, the fundamental rights and duties of citizens and the electoral systems. So this is the definition according to Marxists. We have also another definition according to Shift. Shift tries to maintain that a constitution is a piece of basic and fundamental law. So this is according to Professor Shift, who is a very famous professor in our country and a constitutional law professor. So Shift tries to maintain that a constitution is a fundamental law which tells how the state and its various apparatus are organized. So that is according to Professor Shift. Now, having seen the different definition of constitution, let's see on how or should the constitution always be a written document. Remember, we have said that in Tanzania we are having the United Republic of Tanzania Constitution, which is a written and codified constitution. Should it be a written document all the time? It is said it is not necessary for a constitution to be a written document. We have other countries that they do not have a written constitution, but it is not like they do not have a constitution. Their constitution is recognized by way of practice and some sort of that nature. They have customs, practice, so in that way they recognize as part of their constitution, though it is not a written document. So it is not necessary for I've said here, for the United Kingdom has a constitution which is not engraved on a single document. This is just an example that you can type, like UK. They have a constitution, but it is not engraved in a single document or in a written document. Yet it is argued that the English constitution is a written, though in several documents. So it is not necessary for a constitution of any particular country to be in a written document for it to be recognized as a constitution. You can see, even in a written constitution, not all rules or guidance devices for the working of the government institution are to be found in one document, which we call constitution. Some rules may be partly divided into other legislations. So not all the rules are combined in one particular document we call constitution. So this is all about that it is not necessary for a document to be, it is not that it is mandatory for a document to be, for a constitution to be in a written format. What are the characteristics of a constitution? Of basic features of the constitution? We said constitution deals with the organization of states' power, the ultimate sovereign which in the state. So the first characteristics is that it deals with the organization of states' power. It regulates the state's power. The constitution establishes and regulates the powers of different organs of the states. This is also very known, and the constitution regulates the powers of the legislature, executive, and judiciary. The constitution establishes and provides for the position of the individual. It is also a known feature of the constitution. It also contains the rules of substance and procedure, which relate to affecting changes in constitution as well as election. It governs most of the elections procedures. They have to make sure that they abide to the constitution of the country. The constitution of the country is a fundamental law, a kind of higher law. We describe the main structure. It is, we have said it is the basic law, it is the fundamental law. So it is the, in Tanzania we call it the mother law of the land. And another feature of the constitution, or the characteristic of the constitution of any country, is that in Tanzania I would say one of the characteristics of the constitution is that it is a fundamental law. It is, we call it the mother law of the land. So that is main, or one of the major features of our constitution. It is also the supreme law of the land. That is almost the same as the fundamental, the mother law of the land. So, what ideas do we have about today's constitutions or constitution? As we know, today constitutions or current constitutions originated with the bourgeoisie struggles against feudalism in Western Europe. So we have seen this in the history of emergence of constitutions. The bourgeoisie revolution of 19th century in England, which compelled England to adapt constitutional convention and the basic law of the land. So this is how the constitution of today originated, from the bourgeoisie struggles in Western Europe. This was in 17th century, as I've said. Such conventions, such as Petition of Rights, Bill of Rights, and Act of Settlement had their roots in the Magna Carta of 1215. Secondly, on how today's constitutions emerge, we can see in the 18th century in North America revolutions. These are sometimes known as American War of Independence. Apart from resisting English domination, the revolution further sought to establish a new constitutional order. So we have seen the bourgeoisie struggles, and now we have the American War of Independence of the 18th century. Again, we have the French Revolution of 1780, which led to the overthrow of the then existing monarchy. So all these three struggles led to the emergence of today's constitution. Why revolutions? Why did we have to have revolutions in order to have constitutions? These revolutions did not take place for the sake of replacing the older leadership. These revolutions took place against oppressions by the feudal social and economic order, in which states determined every relationship. So these three revolutions, as we have seen, they did not take place in order to replace the leadership, simply because they were against the oppressions of the feudal social and economic orders. Let's see the examples of American Revolution, which were intended to eradicate British perspective. I've talked of the American War Independence, and it was simply to eradicate British perspective. The revolutions, no doubt, sought to fight against the absolute state in which all authorities and power were concentrated in the monarch. So this is one of the examples of why we had these revolutions. It is simply the continuation on why we had the revolution. It was from such claims that there was the declaration of the rights of man and citizen we had a fight for the people's rights, human rights and so-called inherent rights. So from that fight, we had this declaration, which it was called the Declaration of the Rights of Man and the Citizen of 1789 in France. This document forms the basis of what is today known as the Bill of Rights. In our Constitution, we also have Bill of Rights. So one would ask you, where does Bill of Rights originate? This is how it came into place. Why Constitution then? We have seen the definition of Constitution, the theories on how different scholars defined Constitution. We have seen why, and we have seen different revolutions that led to today's Constitution. And now, why Constitution? Why do we need to have Constitution? I say it is saying that Constitution will normally reflect theoretical beliefs. There is often the desire to have the guiding principles of government in definitive words so that the rulers and the ruled may know those guidance. As I've said, and as we have seen in the previous definition of the document itself, the Constitution, that this provided the guidance to the state, to the government organs. So it is very important in the desire of the community and the government itself to have a proper guidance or to have a principles on how the rulers and the ruled one may be guided. A written constitution acts as a political manifesto. Usually it shows the policies of the government and the type of government in the country. This is also seen in our constitution. It can act as a point of reference. It is also very common as whatever we do, whatever we decide, we refer to our constitution, that according to the constitution. Don't go against the constitution. Any law should abide to the constitution of the country. So it can act as a reference to any government actions as well as justificatory reference by those servants who are implementing the purposes and policies of government. We can now chip in to see what are the written sources of the UK Constitution. We have the statute law, common law, royal prerogative, or convention, work of authority. These are just the sources of the UK Constitution. Written and unwritten Constitution differs widely in purposes, form, and contents. We have talked a bit about this, the written and unwritten Constitution. They constitute and define the legislature and the scope of its law-making power and procedures. So this is all about written and unwritten constitution, and we have the sources of the UK constitution, where we can see part of those sources are also sources of our own constitution. You would like to see a bit of the flexible and rigid constitution. When you talk of flexible constitution, this means constitution which have no special procedures for amendment. While rigid or inflexible constitution, these are constitutions which are amendable by a special procedures. For example, holding a referendum before the constitution is amended. So, for that case, in case of the United Republic of Tanzania constitution, we always hold a referendum for the constitution to be amended. We also have presidential and parliamentary constitutions, whereby under the presidential system, the head of the executive is also head of state, and such a head of state is not a member or directly responsible to the legislature. Example is Tanzania. We also have a parliamentary system, whereby the executive is the prime minister, who is a member and responsible to the legislature. The president, if any, the queen or the king, remain as head of state. So these are just examples of different types of constitutions. We have unitary and federal constitutions. When you talk of federal constitutions, this presupposes a desire for some form of union among independent states, which, though they desire union for certain purposes, nevertheless wish to preserve their identity and some measures of independence. So this is a federal constitution. This is a federal constitution. When you talk, when you want to know how this federal kind of constitutions works, or how it, we can see that we can take examples of the United States of America, Australia, Canada, just to mention few. So, in order to see how federal constitutions works or applies. Let's see unitary constitution. Unitary constitution presents the most completely developed form of federalism. The supreme legislative authority is exercised by one central power instead of decentralizing it. So this is a unitary constitution. Examples, we have examples of this kind of systems. We can see them in UK, where they have a unitary state. So we have seen, in this lecture, we have seen the constitution, the history of the emergence of the constitution. We have seen the different definition of the constitution from different scholars. We also see the different kind of constitution, and we have discussed on what kind of constitution do we have, and the last but not least, we discussed the characteristics of the constitutions of any country. Thank you.